Welcome to the November edition of This Month in Payroll for 2024. I'm Rowan Geddes, National Leader of PwC's Payroll Advisory and Operations Practice. This month, we will review the annual reports of the Fair Work Ombudsman and the Fair Work Commission, summarising their activities over the last fiscal year and the areas of focus for the next year. We'll also consider the 8 pertinent questions that the Fair Work Commission has posed around working from home, as well as review the safe harbour rules provided in the Fair Work Act's new criminal penalty provisions for underpaying wages with intent, coming in on the 1st of January. First up, the Office of the Fair Work Ombudsman released its annual report this month. Once again, the headline is the amount of back payments recouped by the FWO. This year, it was $473 million, with the bulk of this, $333 million, coming from large corporates, driven in the majority by self-disclosures initiated by employers trying to get things right. Underpayments recouped from investigations into complex matters and from the issuance of compliance notices have remained basically constant over the last 2 years at $33 million. However, one big change has been the increase in court-ordered penalties, which rose from $3.7 million to $21.2 million. Even putting aside the 2 biggest penalties handed down this year, Commonwealth Bank at $10.3 million and Din Tai Fung at $4 million, court order penalties have almost doubled in FY24. This stat underscores the FWO's increased predilection for requesting court-ordered penalties and is particularly noteworthy given that the new civil wage theft penalty regime, allowing for a 5-fold increase to penalties, commences on 1 January next year. In the annual report, the FWO listed out the typical drivers that it has found leading to wage underpayments in large corporations. This list is an excellent checklist for boards and senior leadership teams as to how to establish a payroll processing and controls environment that is more likely to prevent errors or, if they do occur, to discover them early. It also gives clear guidance as to what the Fair Work Ombudsman will expect to see put into place when it considers how to respond to a disclosure or a discovery. These drivers are, first, a lack of investment in payroll systems, expertise and staffing. Second, absent or insufficient compliance checks and auditing, particularly over new enterprise agreements or entitlements. Third, not ensuring a line of sight between the risk controls in place at a corporate governance level and what is actually happening at the workplace level. Failing to monitor and act on instances of non-compliance, because even apparently isolated instances could be an early warning sign of more systematic contraventions. Fifth, setting annualised salaries for award-covered employees too low to compensate for all the work actually performed or not reviewing the buffer regularly. Sixth, failure to A. Properly map roles to correct classifications of job grades. B. Implement enterprise agreement obligations and pay rules, especially regarding undertakings and reconciliation clauses. And C. Failing to conduct assurance checks on system configurations. And finally, requiring manual or compliance-based processes for entitlements, such as higher duties and allowances. In addition, the university sector was specifically called out as a priority area for the FWO in 2023-24, as the office has found that employers in this sector to be largely systematically non-compliant, often due to the high number of casual workers in the workforce, plus governance concerns, including a lack of investment in payroll systems expertise and auditing. That said, the FWO has recognised an improvement in the sector's acknowledgement of systemic issues. Of the 42 universities in Australia, more than 30 have engaged with the FWO. As part of the FWO's proactive collaboration approach, it has engaged with peak university bodies, such as the TEQSA and the Australian Universities Accord Panel, resulting in commitments to develop new criteria and annual reporting requirements for higher education providers regarding their management processes in relation to workplace relations compliance, including specifically casual staff numbers. The FWO's role is not, however, limited to ensuring compliance with workplace laws. It also has a role to educate, assist and provide advice. Given the amount of workplace reform and legislative amendments that came into effect last year, it is not surprising that the demand for advice has risen sharply. Traffic through the Fair Work Ombudsman's website increased by over 8% this year, driven by the launch of new information on new legislation, such as the Closing Loopholes and the Secure Jobs Better Pay Acts, the Protecting Worker Entitlements changes, family and domestic violence leave, and the Respect at Work changes. There has also been an increase in demand for fact sheets and best practice guides, in particular the Casual Employment Information Statement and the Fair Work Information Statement, while demand for the Ombudsman's online learning courses has increased by 15%. The Fair Work Ombudsman also continues to refine and promote its apps, including the Pay and Conditions tool and, interestingly, the rebuilt Record My Hours app, which empowers workers to keep track of their own hours in case employers fail to do so. The top 3 industries who were the users of these tools last year were hospitality, building and construction, and retail. Next, we explore the Fair Work Commission's annual report. If the Ombudsman had a busy year, spare a thought for the Fair Work Commission. In this period of immense change, this is the Fair Work Commission's words, the Commission saw applications rise by 27%, resulting in the highest rate of lodgements received by the Commission since the inception of the Fair Work Act in 2009. Despite these record lodgements, the Commission has maintained its effectiveness, processing 92% of all applications within 3 days of lodgement and finalising 96% of all matters within 16 weeks of lodgement. In addition, the Fair Work Commission dealt with the expansion of its functions and the conference of new jurisdictions as a result of the Closing Loopholes legislation, including workplace entry rights, regulated labour hire orders, same job, same pay, fixed-term contracts, and protections against discrimination for those subject to family and domestic violence. It also prepared for the reforms which commenced on the 26th of August of this year, including the right to disconnect, a new definition of casual employee, a new casual conversion pathway, and changes to the definition of employment for the purposes of the Fair Work Act. And finally, the Commission undertook and delivered a substantial number of major cases during the year, in addition to the annual wage review. These included the aged care industry work value case, resulting in an increase to wages to workers in the aged care industry, the early childhood education and care industry supported bargaining application, the Modern Awards Review, which included consideration of 4 priority topics: the arts and culture sector, job security, work and care, and award simplification, the commencement of the Gender Undervaluation Priority Awards Review, and the variation of awards to include a delegate's rights term. In total, the Commission has undertaken over 70 projects to support a smooth transition into this new era, establishing working and advisory groups, running major cases, and developing practical tools and resources, including fact sheets, templates, guides, and implementation reports. So, in summary, we continue to operate in a time of immense IR change. While there has been a reprieve from new legislation following the flurry of activity that came through with the Secure Jobs and the Closing Loopholes bills, there are still changes to come through as a result of the staggered implementation dates. Criminalisation of wage theft and higher civil penalties is the obvious one, and the Fair Work Ombudsman has made it clear about her expectations of large corporates in relation to payroll governance. Meanwhile, the Fair Work Commission's agenda for reform in 2024-25 includes such significant items as gender-driven undervaluation, work from home, and award simplification. It is clear that we will still have items to talk about next year. While we're on the topic of key reform agendas, one of the priority matters that the Fair Work Commission has commenced proceedings on is developing a working from home term in the Clerks Award. As part of that process, this month, the FWC provided a list of 8 questions that they would consider in relation to inserting a work from home term into the award. This is relevant because it will likely provide a broader template for all modern awards. The 8 questions are: 1. Are variations to the Clerks Award necessary at all to achieve the Modern Awards objective in relation to working from home? 2. How should working from home be defined? 3. Should an appropriate working from home term include a right for employees to request working from home arrangements? If so, in what circumstances should that right to a request be available? And in what circumstances can an employer refuse the request? 4th, What modifications are required to deal with some of the specific working hours clauses in the award? For example, the definition of ordinary hours, the fact that ordinary hours are to be worked continuously, the limit on the number of ordinary hours to be worked in a day, the requirement to provide breaks, and impact on allowances. Fifth, how will the employer obligations in respect of overtime operate alongside a working from home term? In particular, how will the working of overtime hours be authorised and recorded? 6. Should working from home apply to all classifications or just to specific groups of employees? 7. How would a working from home term interact with the right to disconnect? And in case that wasn't enough, 8. Any other matters. Our modern awards did not contemplate the rise of flexible work impacting locations and hours. Instead, the awards are built on basis of traditional working hours and the concept that typically work is undertaken at a work site. Therefore, the need to address these inbuilt conflicts to modernise our modern awards is clear. That said, these are difficult questions, so we look forward to the progress that the Fair Work Commission makes in resolving them after consultation. However, the process won't resolve quickly. The FWC has given interested parties until March 28th next year to file proposals for a working from home term, and after subsequent submissions, it's expected that the directions hearing will not occur until June the 6th at least. And finally, as employers look ahead to the 1st of January and the start date of criminal penalties for wage theft, we noted the Fair Work Ombudsman's presentation at the Australian Labour Law Association conference this month. In the presentation, the Ombudsman raised a soon-to-be-published voluntary code that will serve as a blueprint for all employers when responding to the new environment. She also recounted that there are 2 safe harbours provided in the Fair Work Act's new criminal penalty provisions for underpaying with intent. The first is for small businesses, while the second safe harbour involves cooperation agreements, which are available to all employers that self-report matters that would otherwise expose them to criminal liability. The Ombudsman emphasised that the cooperation agreements won't be available if the Ombudsman identifies the underpayments through an investigation or through a proactive visit. However, when an employer self-reports, there is the avenue of cooperation agreement designed to incentivise good behaviour that will prevent the referral of criminal conduct to the Director for Public Prosecutions or the Federal Police. Regulators, advisors and employers will all take some time to settle into the new wage theft regime when it comes in on the 1st of January, as we work out the circumstances in which the Ombudsman and the courts will enforce both the penalties and the direction to remit. However, there is no shortage of guidance coming from the Fair Work Ombudsman about the Office's expectations of large corporates, between the drivers of wage underpayments listed in the annual report, the release of the 8 Principles of a Good Remediation Program, and this soon-to-be-published voluntary code. And that's it for our November edition of This Month in Payroll. If you would like to revisit any of our prior updates, they are available on our website at pwc.com.au/payroll. And if you have any questions or need for support, please reach out to myself or your usual PwC comment. And as there won't be a December edition of TMIP, that's also it from Claire and myself for the year. Thank you for your continued patronage throughout the year, both listening to this update and also attending our Workforce Leaders forums. Good luck with the rundown to the end of the year, and we will see you next year.